Good afternoon. Thank you for coming to our presentation on transnational arbitration, a new and exciting area of the law in this global economy. To get things started, I'd like to introduce myself and my group members. I'm Kaitlyn Girard, a third-year law student at Wake Forest University. Joining me in this presentation are Nathan Gravlee, Dylan Greenwood, and Jason Hornsby, also second-year students at Wake Forest. In addition, we're excited to present video clips later in this presentation of prior interviews with two experienced practitioners. Andrea Karska-Shepard from the law firm Smith, Moore, and Leatherwood represents clients in a variety of international matters from her practice in Raleigh, North Carolina, and Prague in the Czech Republic, as well as Dan Zaslowski, who practices in the area of general commercial litigation and arbitration at Baker & McKenzie. To get things started, we'd like to explain our presentation through a hypothetical. Thornbush International, a High Point-based furniture company, is looking to enter into a contract to purchase 5,000 antique keys from the German key maker Hans von Kiesten Corporation to use with their new line of furniture to debut this spring. Thornbush Inc. has approached you to discuss the international transaction and to draft the contract for the sale, including an agreement to arbitrate should a dispute arise concerning the transaction. Mr. Thornbush has commented to you that he is certain the transaction will be no different than any other domestic contract you have drafted for him in the past, but is this assessment correct? No. The international arena presents an entirely different situation than domestic contracts and arbitration. Now I'd like to turn things over to Dylan Greenwood.
During our presentation today, you will take away some key things that you will be able to take back to your law firm in the area of transnational arbitration. One of which is the purpose of transnational arbitration. But most importantly, you need to know which international arbitration organizations control. You need to know how to draft an effective arbitration agreement. This is where you will probably make the most impact. It's where you're going to save yourself a lot of heartache and a lot of trouble. You will also know after this presentation how the process works during transnational arbitration. And then another important key fact is how to enforce your award. Once you get that award, you need to know how to collect on your award. And then if it is not in your favor, how to rectify that. So why should you choose arbitration? Why should Thornbush Incorporated choose arbitration in their agreement with Hans von Kiesten Corporation? You have to take into account, is it more efficient than litigation? Often this is the perception, and oftentimes it is, although sometimes it has been known that arbitration organizations have taken a while, years in fact. Is it easy to enforce against a foreign corporation or a foreign entity? Due to certain conventions, this has now become the case. However, this is one of the major aspects of arbitration, why you should choose it over litigation. Also, what sort of terms should govern during the arbitration? You need to talk about this with your client. And then what is the practical impact of having transnational arbitration versus litigation? So in today's market, with it growing, constantly changing, just how dynamic it is, disputes are going to arise. And disputes are going to arise for Hans von Kiesten, for Thornbush Incorporated. Our company in our hypothetical cannot be so naive to think that they aren't going to. So you need to include an arbitration clause. And arbitration is the way to go in the international arena because litigation is just not feasible. You have jurisdictional issues, you have issues of what choice of law you should have. You do have these issues in arbitration, but you can talk about them beforehand and make a decision beforehand. You can't go to one country over the other and get a judgment and try through litigation and try to enforce that in another country. Germany, for instance, in our hypothetical, is not going to enforce a judgment from the United States court, and you're not going to get your award. So some of the advantages and disadvantages. Arbitration does provide a neutral forum, provides a neutral forum in the sense of the neutral procedural laws you can pick and the neutral substantive laws you can pick. It is confidential. This does aid in, you don't want an adverse award going against you that would maybe have stock ramifications. It might cause consumer confidence to go down about your product or whatever you're trying to sell. So this does keep it out of the media, whereas if you do litigation, it is going to come into the public domain. Oftentimes, arbitration is quicker, it is more efficient, and you can choose how you want the arbitration to occur, what arbiters you want to get involved, what institutions you want to get involved. Some of the disadvantages, however, are that arbitrators don't have any coercive power, and you don't have a right to appeal if there is an obvious error against you. And also there's less discovery in arbitration, although you can put provisions in the arbitration agreement to take care of that. So one of the major concerns if you're thinking about an arbitration agreement is whether you should do institutional or ad hoc arbitration. Institutional arbitration is just like it sounds. It is done through one of the key arbitral institutions throughout the world, and there are some tried and true tested organizations that are used commonly in today's market. And they have their own sets of procedural rules. They have their laws that they want to pick. They even have their rules for how they pick arbiters. So these are a great way to go, as oftentimes this is the recommended way to go. However, if you do want to have more control over what you do with the arbitration, you should use ad hoc arbitration. In ad hoc arbitration, you don't use an institution, but you pick how the arbiters are picked, you pick the choice of law, you pick the procedural rules. You have the control here. And that may sound provocative to some attorneys to be able to use that. However, you have to be careful doing this because if you fall short in your drafting, issues can arise. So here's some of the major international arbitrations and arbitration institutes that are used. All these are very well respected organizations: the London Court of International Arbitration, the ICC. AAA is the American version. If, for instance, you have to be careful using the AAA because of perception that it gives American companies a home court advantage. So you can go for that in your negotiations, but don't necessarily expect it. Here's the arbitration agreement. This is the bread and butter of what you are going to talk about today, and I would like to turn it over to Jason Hornsby to talk about that.
So we're talking about arbitration, and we first start off, how do we get to arbitration? So how are we going to get to this method of arbitration? When you're dealing with arbitration, you're essentially giving up the right to have a judicial enforcement and judicial proceeding. So you're giving up a right, but you're gaining a substantial right in having the matter decided in arbitration. Parties can start with arbitration by having an arbitration clause within the contract or a separate arbitration clause in a separate contract. Likewise, parties can also have a dispute where they haven't actually given a provision for arbitration in their contract, so they decide after, once they get to a point where there is a dispute, that they want to have arbitrations. So this would be a submission clause. So a practical point, when you're an attorney and you are advising a client, you want to make sure that your client has an arbitration clause in their agreement. The reason being is when you have a submission clause, you're deciding after the dispute has already arisen. And most likely, parties, once they get to this stage, they're not going to agree on anything. So it's going to be difficult for the parties to negotiate anything once there is disagreement among themselves. So let's go to the doctrine of separability. So what is separability? When you're looking at the doctrine of separability, it's basically a term that says that the arbitration agreement itself is a separate contract from the original contract for the parties. So if the parties have an agreement between themselves and they say that the validity, one company challenges the validity of the contract and says that it's not a valid contract, therefore the arbitration agreement is not a valid contract. Well, the doctrine of separability provides you some support saying that even in spite of the contract being inoperable or in spite of the contract being invalid, the arbitration agreement continues to be valid. So when you're looking at the validity of an arbitration agreement, you're going to look at three essential things. You're going to look at a writing requirement. You're going to look at a defined legal relationship. And you want to make sure that the contract is capable of being settled by arbitration. So when we look at that arbitration, when we look at the writing requirement, I'm going to give you a practical tip. you want to make sure that your contract to arbitrate is in writing, and you want to make sure that both parties have signed that contract, that the arbitration agreement is in writing. And I'm going to give you another practical tip. With regards to that defined legal relationship, a prudent attorney will have language within the contract that says all disputes arising or related to the contract can be arbitrated. Now, this is a very prudent move to do on your behalf. You want to measure and make sure that this is going to be in your benefit. But what this does is make sure that matters that could be tortious, business mispractice, bad business conduct, it can be arbitrated, and it will be arbitrated with this broad terminology if you put that in your arbitration agreement. So remember, arising out of and related to the contract. Have that language in there. And then you want to make sure that the matter is capable of being settled by arbitration. When you're looking at capable of being settled by arbitration, criminal acts, they won't be able to be arbitrable. Family matters, child custody cases, bankruptcy types of events, those are not arbitral events. So you want to make sure that the matters that you're stipulating to be arbitrated in your contract agreement are arbitrable. So let's go to our expert, Andrea, and see what she has to say on the matter.
In the international arena, you have to have a cultural sensitivity to the other party. You have to be understanding that they might perceive not only culturally but legally the situation as different, and you have to find a compromise, something which will work with both parties. You don't want to have to go to the arbitration and right away have some kind of animosity between the sides. So let's say you have a client which wants arbitration, but doesn't have an arbitration agreement. So you have to consider with the other, like you as a U.S. attorney, you have to consider whether you are going to do ad hoc arbitration or institutional arbitration, and where you are going to do it, which would be the jurisdiction. For arbitration, the place of arbitration is very important because it determines the procedural rules. And some countries are more friendly to the arbitration, international arbitration, than the others. And so if, let's say, you have to have an institutional arbitration, you want to decide about institutional arbitration, ex post facto, you didn't have it in the agreement, but you want to agree when the conflict arose. Then you can kind of see where the other part is geographically located. If it's Asia, whether it's Europe, what's the geographical location, what makes sense in terms of placement of the parties. But then also, as I said, you look on the countries which are more pro-arbitration inclined. And as we know, there are big arbitration institutions in London and Paris, ICC for example, in Paris, and LCIA in London. And these countries are known that they do not interfere very lightly, and the courts do not interfere very lightly with the arbitration. So you may, for example, just a forum like that, which would be outside of the United States, but which would, would be a safe choice in terms of enforcement of the judgment, non-interference with of the court with the procedure. It would be something which would be predictable and fair for both. So you have to kind of a little bit get out of your territory, and maybe if you can select that the venue would be like the hearings would take place in the United States, but the procedural rule, arbitral suits would be like, for example, London or Paris or some major venue like that, which would be kind of neutral maybe for the other part.
So let's turn to the hypothetical with Thornbush. So in Thornbush's arbitration agreement, what does Thornbush want to do? What should we give him as guidance as an attorney to the client? Well, first and foremost, as an attorney for Thornbush, you should more than likely guide him towards institutional arbitration, which means going to a jurisdiction or a country that provides for institutional arbitration. And going into institutional arbitration, I would probably advise Thornbush to go to the ICC, one of the most prestigious organizations that would be able to have more credibility. Also, you would want to have that language that I advised you of, all disputes arising out of and related to the contract, to cover tortious acts. And also, you would want to advise him to be aware of of the situation and don't just assume that arbitration won't happen. Now let's turn to drafting your arbitration agreement. This is why you're here today, and then this is what's going to separate you from the other attorneys out there. Specifically, when you have arbitration too often and too many times, attorneys have bad drafting language in arbitration agreements. The reason for this is oftentimes companies and attorneys draft arbitration agreements after they've had extensive time in drafting the contract, so they're tired. Their resources are depleted and they're tired, and it's kind of an afterthought. Also, you have more transactional attorneys that are doing arbitration agreements, and then this is where this course is going to come into play, giving you the benefit of being a transnational arbitration attorney. You'll have this guidance that will set you apart. Too often, if you have that well-drafted arbitration agreement, more than likely, this will dissuade parties from bringing claims when you have that good contract language for the arbitration. So let's turn to our expert, David Zaslowski, and see what he has to say on the matter for the terms of an arbitration agreement.
And so if we think about the basics of an arbitration clause, what do you need? What is the essential parts of your basic arbitration clause? The first issue is what disputes will be arbitrated, because you can agree to arbitrate some and not all. But if you do want to arbitrate all of your disputes, then make sure you use language that is tried and tested by the courts already. The second point is commit to arbitration, and the most important lesson there in terms of committing to it is use the word shall. Don't leave open any question about whether the parties definitively intended to arbitrate their dispute. Another important basic component of an arbitration clause is pick the arbitral institution. If you just say, we agree to arbitrate, and you don't pick the institution, well, when you have a dispute, one side is going to say, I want to arbitrate before the AAA, and the other one is going to say, I want to do ad hoc arbitration. You're back to having a dispute about what does your clause mean. That's what you want to avoid. In the parenthetical it says, or appointing authority. What that means is if you have an ad hoc arbitration, then you're not going to have an institution, but you should nevertheless designate who will make the appointment of the arbitrator in case either side doesn't appoint theirs, or in case the parties cannot agree on the chairman of the tribunal. You also should choose the number of arbitrators, and of course that should never be an even number. 1 or 3 are the most typical, and one is usually used in a case that is not a lot of money. In smaller cases, you could justify 1. The bigger the case gets, the less likely you are going to want to just put your fate in the hands of a single individual. You should also specify the language of the arbitration, and in the international arena, you do sometimes have contracts in which it's drafted in more than one language, and each language is actually an official version of the contract. Or you might have a situation in which your contract is in a particular language, but it is being performed in a different country, and so all the correspondence is in a language other than the language in the contract. If you have those situations, especially, you should designate in your clause the language of the arbitration. You should specify the location of the arbitration as well. We'll talk about that a little more later. The location is a critical part of your arbitration, and you don't want to leave that for a decision after a dispute arises. And the last point, provide for entry of judgment. This is something really that is specific to U.S. law and U.S. practice, and if you envision having to enforce your arbitration award in the United States, then to avoid a split in the courts about which district court might have jurisdiction over enforcing the award, you should provide for entry of judgment in a court that has jurisdiction.
So Mr. Zaslowski gave us a few tips. So let's go to the essential terms of your arbitration agreement. These are the terms that you're going to need to have in any arbitration agreement that you have between the parties. First, you're going to look at what method of arbitration are you going to have. You're going to have institutional arbitration or ad hoc arbitration. Now, for the international format, I want to advise you that China does not adhere to ad hoc arbitration, so that won't be a choice. Next, you're going to look at how many of the arbitrators are you going to have? The selection of the arbitrators, that's going to be a fundamental thing that you're going to have to decide. Typically, you'll be looking at whether you want to have 1 or 3 arbitrators. You're going to look at What type of claim is it? Is it a $500,000 claim? Are we looking at above $1 million? So that will be something to consider. You're going to look at the place of arbitration. You want to have a place of arbitration that is good for both parties. And I'll give you a practical tip. Always choose some place that you would go on a vacation to. So never choose a place that doesn't have sufficient infrastructure or that might be in political turmoil where the place wouldn't be in existence at the time of arbitration. The language of arbitration. Now, another practical tip. Your client's not going to be happy if you fail to choose the language and they're paying translation fees. You might be putting yourself in grounds for malpractice, so watch out for that. Also, the substantive law. You have to choose what law is going to govern the contract. So those are the essential terms. Now, what about additional terms? More than likely, simple is going to be better. But if you're an expert on this field, you might want to have additional terms. You might want to have provisions for more evidence. If you're dealing with antitrust issues, you might want to have more evidence rules that would apply to litigation, more of the litigation format. You want to have preliminary relief. You want to look at if the other party is trying to hide assets. You might need the court to intervene and seize those assets. Do you want to have technical experts? Do you want them to be arbitrators? And do you want to have multi-step dispute resolution clauses? As a practical tip, I'll tell you that multi-step dispute resolution clauses, they're typically a courtesy trap. Generally, you're just taking steps from mediation to arbitration to further steps, ultimately litigation. So it's typically just go straight to arbitration. Legal fees. Always, you want to have that discussed prior to the matter. So discuss the legal fees. One of the biggest issues is confidentiality. This is a key that you want to have in your arbitration agreement, and you want to make sure that you have confidentiality of your experts, of your witnesses, to protect the company, protect your client. Waiver of state immunity. This is another term. If you're going to be arbitrating against a state or state entity, they might try and use their state immunity. So you want to have a clause in your arbitration agreement that the state waives that right to state immunity, and multi-party agreements. So these are all additional provisions that you would want to consider after you're an expert on the matter. So let's turn to our expert, Andrea, and see what she has to say.
I'm careful about the clauses like choice of law, choice of forum, arbitration, which do not necessarily get as much attention by some practitioners, which are just like practitioners in their local jurisdictions, whether it's US, Canada, or other countries. They don't look into these other clauses as maybe as important as some clauses about price and obligations of the parties. So I just want to say that I pay very close attention to these clauses because you always have to think in your life as a lawyer with the end of the mind. You have to think when you are drafting contract, what if the things go wrong? Like say, what if there is a dispute? So then you want to select and draft it in the best interest of your client, and that would fit that particular need of the client and would give him a fair and good place for him or her to bring this dispute. And when I do arbitration clause, I also keep kind of thoughts about the cost.
So let's turn back to Thornbush's arbitration agreement and what elements that Thornbush and the attorney for Thornbush should advise him for the essential terms. First, he'd want to have the language arising out of and related to the contract. Also, he'd want to have that confidentiality clause. He'd want to have a method of arbitration for institutional arbitration. And likewise, he'd want to make sure that in conducting this arbitration, he'd want to have the language as English, to protect his client. So we're going to now turn to the applicable laws and rules. And I'm going to turn to my colleague, Nathan, for this.
Okay, the applicable laws and rules section is going to be very important. It is sort of going to be the meat of what's going to control as you move through an arbitration agreement. Also, we've already spoken before about whether it's ad hoc or institutional arbitration, but really this is going to be, you're going to have more control under the ad hoc to decide which principles you want to govern. But under institutional, you're going to kind of know what you're going to get. So that's kind of important. Choice of forum can be also a big thing, but the rules are not necessarily going to go with the forum in every instance. Okay. The choice of law applicable to the arbitration procedure is what's going to hopefully be hammered out by the parties ahead of time. This is going to be negotiated, and it's going to be basically the law that's going to control. Oftentimes in a large international arbitrational commercial transaction, it's going to be a neutral law, so it's not going to be the law of either party. It could be the law where the arbitration is going to sit, or it could be another neutral law, but it's often not going to be the law of either one of the parties. The choice of the arbitral rules, as we've said, under ad hoc and institutional, this is going to be slightly different. However, the arbitrational rules are often going to come with the choice of the arbitrators that you choose to use. The law governing the arbitration agreement's substantive validity, and this is going to be the law that's going to govern the contract terms. This is not going to be the arbitration process itself. This is going to be the substantive law that's going to govern the provisions in the contract. The law governing arbitrability, it was touched on a little bit before, basically brings up the important question, is the issue arbitrable? And if it is, how are we going to proceed under that? The choice of law governing the contract is really what's going to be one of the specific portions of what's going to be involved in an arbitration agreement. Okay, the regulatory framework, this is important to remember, and when you're looking at this, you really want to think of it as kind of an upside down pyramid or triangle, and you want to start really broad and think of the international treaty first under the really broad scenario. For almost all the countries that you're going to be involved with a commercial transaction, South American countries, basically all of Western Europe, and basically almost all the developed nations in the world and many of the developing nations of the world are going to be signatories to the New York Convention. This is pretty much the convention that governs international arbitration agreements. It's really the document and the one that's going to really control pretty much all the arbitration stuff that's going to happen on an international level. The international arbitration practices may be used as a guideline by the arbitrators, and this is going to be slightly narrower, and this is basically arbitration practice law that's used that could supplement the convention if it doesn't explicitly spell it out, and the parties are not going to be the ones, or the parties weren't the ones that really kind of hammered this out ahead of time. National laws, this is a bit narrower, and it's the substantive law chosen by the parties, and this is going to interpret the contract, the merits, the dispute, and the substantive issues. So hopefully, again, chosen ahead of time. Hopefully it's going to be a neutral law, but it's going to be one that the parties negotiate, and the arbitrators are generally not going to supplant it with their own unless it's really obvious that it's just out of left field. The arbitration rules, again, it's really going to come with the arbitration panel where it sits, and you really are not going to have a ton of control over the procedures unless you are proceeding under the ad hoc basis, and that's going to be slightly different. The arbitration agreement is going to be the agreement between the parties. As was already said, it's more or less a separate agreement from the contract, and it's almost totally by the parties that they're going to decide this. Just a bit of clarification. I assume that many of you have heard of the choice of law and choice of forum clauses before, even if you've only dealt with U.S. domestic practice. However, it's important to go back over and really understand how they work in an international arena. Choice of law clause names a particular state and provides that substantive laws of that jurisdiction will be used to determine the validity and construction of the contract, regardless of any conflict between the laws. This is dealt with oftentimes between the states and the United States, and we have choice of law provisions in U.S. domestic practice as well, and it's going to work largely the same way in international arbitration agreements. The choice of forum is also a provision that we're well aware of in U.S. domestic practice, and it's basically going to be where the arbitration panel is going to sit. One modern trend is called voie directe, and it is really a trend in international arbitration that's allowing more and more for the arbitrators themselves to get to have more substantial discretion than they did in the past. if there's rules or laws that really should be applied, but that they're going to have an unduly harsh impact or unduly harsh result on one of the parties that's really not intended under the rules or under the laws, they're going to have a lot more discretion than they would in the past to really kind of supplement it with their own stuff and to make sure that it comes out a little more fairly for the parties.
So now I'm going to talk about transnational arbitration in North Carolina. Up until this point, we have told you that more likely than not, representing a domestic client, you're probably going to pick a forum that is probably outside of the United States. However, other countries may see the United States as their neutral forum, and some states have enacted legislation specifically regarding transnational arbitration. There have been 10, and North Carolina just happens to be one of those 10. North Carolina general statutes do cover these issues, and they've been codified mostly to explicitly state chapters 1 and 2 of the FAA, the Federal Arbitration Act, and also potentially go beyond the FAA and address issues that the FAA has not. You may be sitting there thinking, well, does this bring up issues of preemption? It has not been challenged yet by the Supreme Court, or before the Supreme Court, and it's not really expected that it will be a contentious issue, because oftentimes the state laws go beyond what the FAA does. They were not designed to conflict with the FAA, and the provisions only really apply when the FAA does not. And oftentimes there is arbitration and there are awards that fall outside the scope of the FAA, which do fall under the purview of these state laws. So North Carolina statutes authorize North Carolina state superior courts to intervene. They can intervene and enforce arbitration awards. They can provide assistance to further the arbitration along. And this can be key. Sometimes clients or parties may not want to adhere to the arbitration clause, and these courts can use stay orders and orders compelling arbitration to further it along. They can also confirm and vacate awards. And there's a North Carolina general statute that does expressly recognize and enforce international arbitral awards. The New York Convention is the convention that governs international arbitration. This is the convention you need to know. This is the governing body of law that you absolutely need to be familiar with. However, depending on which country that you are doing the arbitration, or the corporation in the country that you're doing the arbitration with, you need to be mindful of how they perceive the New York Convention. So the mechanics of the convention, it does allow you to go to a foreign country with a valid arbitral award and enforce the judgment so that you can get the property that you are awarded. There are some limitations. Countries can make specific limitations to the New York Convention based off what they see as a fit within their public policy. United States, for instance, does not recognize sports-related arbitration yet. That's one of the limitations that we have. The recognition, which is in Article 2 of the New York Convention, states that in general, all the countries that adhere to the New York Convention do have to recognize arbitration agreements as being valid. They have to show deference to those. And then finally, Article 2, the stay of litigation, requires that contracting states refer parties to arbitration if they do get into a dispute. As you can see, participation in the treaty is worldwide, as was mentioned before. Really, the only countries that are not involved are a few South American countries, some in Africa, some in the Middle East, but the vast majority of countries adhere to the New York Convention in some way or the other. And these are probably going to be countries that your clients are going to be doing business with. So turning back to our arbitration agreement with Thornbush Incorporated, we would shoot for having arbitration in London. It is a forum that is neutral. It's neutral between Germany and the United States. I believe Andrea, our expert, talked about how Paris is a frequented place. However, France is right beside Germany. So it may not be quite as neutral as you would like it to be. So London does provide that neutral forum. You would want to follow, you could specify the procedural rules that you want to follow. London does have its own, the London court does have its own procedural rules, but maybe you want to switch it up and use ICC rules. That's possible as well. And then we would specify one arbitrator in this proceeding just because the price, while the potential award is high, it's not high enough to warrant 3. So now you have this arbitration agreement with Thornbush. He's agreed to go through with it. Let's further this along and say, well, what happens if the transaction falls through? So all of a sudden, the keys that you wanted, your client wanted, don't fit. And Hans von Keystone Corporation is not going to rectify the issue. And you've gone through settlement proceedings, you've tried to work this out with them, and they're refusing. Your client's going to come to you and say, well, this stuff's broken down. How are we going to proceed? What am I going to expect from this arbitration? What am I going to expect from transnational arbitration? I'm not used to doing this. So what are you going to tell your client? And that's what I'm going to turn over to Jason Horton.
So we're talking about the arbitration process and what specifically goes on in this proceeding. So when you look at arbitration, there's going to be a couple of things that might be different than the litigation prospect. First, you'll have the notice of arbitration. Then you'll have the response, which will include some pleading materials. So the claimant will make a notice, and then the respondent, he'll have that response. The arbitrators will be appointed, and this will be based on either the institutional method or the ad hoc method, whichever method the parties choose. And you'll have organizational meetings. Then you'll have pre-hearing disclosure. You'll have the oral hearings, and you'll also have deliberation and decision. And finally, the enforcement of the decision. So typically, there's a presumption in most courts and most jurisdictions that arbitration is binding and arbitration is preferred as opposed to litigation. So when you're looking at that, the courts don't often get involved. Now, I will note this. If you're arbitrating in U.S. jurisdictions and you're arbitrating on whether the matter is arbitrable, U.S. courts have the presumption in the reverse as opposed to the international community. So U.S. courts will decide if the matter is arbitrable. So that's one difference between arbitrating in the U.S. because the courts will get involved as opposed to letting the arbitrators decide their jurisdiction on the international community. So the courts will get involved with enforcing the judgment. The courts will also get involved with interim measures. They'll get involved if you need to seize assets that the party is trying to hide, or they might get involved with trying to give you some sort of preliminary relief that you need. Also, the courts will also get involved with obtaining evidence. What happens when you have evidence that's abroad? You have a foreign national that has evidence that's in another country that you're not arbitrating in. So you're going to have to definitely get the courts involved in something like that. I'm going to give you a couple practical pointers. Arbitrators do not like when you badger a witness. This is not typical litigation. We're not in a really adverse setting. So an arbitrator wants you to be friendly. So when you're in arbitration, be friendly, be kind, be respectful. Otherwise, the arbitrator, he'll look unfavorably on that. Also, know that hearsay evidence will be admissible. Now, the arbitrator will weigh this evidence and he'll decide how to use it, but it will be admissible. Also, documents will be presumed to be authenticated. So unless you challenge, so that's why it's a good thing to look at the documents. Make sure that you, as the attorney, don't have any complaints about them, because you have to challenge that document's authentication. Otherwise, it will be presumed to be authenticated, and your client might be looking at you for malpractice. Also, let's go back to our expert Andrea and see what she has to say on the matter.
Being in arbitration, I have been on ICC and other arbitrations as a counsel for the parties. You have to be, of course, compliant with your client's needs. Sometimes what I found a little bit difficult is I would perceive that the case still has some life in it. We should have gone forward in that case, and the client felt that it's time to settle the case, and he or she felt that it's no reason to pursue any further in that kind of matter. And in that case, you can give your best advice, but you couldn't really go against the wishes of your client. So your hands are a little bit tied there, and you have to be sensitive to that issue, and you're not your own boss. It's your client who at the end determines whether you continue or stop. Yeah.
So let's go and turn to the next important part, the award and the enforcement. For this, I'm going to turn to my colleague, Kaitlyn.
Okay, the awards and enforcement, this is going to be the major situation that your clients are really going to be important with. They are really going to be concerned with their award, both getting the arbitration award and being able to have it enforced so that they are able to receive the money that they feel is due under an arbitration, especially in an international arena. Okay, back to the hypothetical. Let's say that we go through all the arbitration procedures and the arbitrator rules in favor of Thornbush, our client. What are we going to do with the award once we have it, and later on, how are we going to enforce that award? These are the 6 major situations under the award that we're going to want to deal with, and I'm going to go through them step by step and explain them in detail when you have an award and the parts of the award. All right, the types of the award. A final award is very similar to a final award in a court proceeding. If it's the highest court, it's really going to be the final decision, and it's going to be an award that the tribunal says that the party gets after resolving all the issues that were before it in the arbitration agreement. A partial award is where the parties have a contract and they have an arbitration agreement, but for whatever reason there's one major issue that they can't get over. However, they agree on other issues, or the performance of the contract can go on. So they submit for arbitration a single issue or a couple of issues for the arbitration panel to decide on, so that once they have what they want under the partial issues, they can continue performance under the contract once they have a real decision under that. An interim award is basically when one of the parties gets an award in the middle of the case. Basically, if they've proved their evidence or one party's evidence is just not nearly good enough, they're going to get the interim award before arbitration is fully complete. A consent award is sort of like a settlement procedure. It's where one of the parties, they thought they had a case, maybe something went against them midway through, but they decided to go ahead and give the award to the other party so they can either move on with the contract or just be out of it, which is probably what they're going to want. And lastly, a default award. This is very similar to a default judgment in a court proceeding. It's basically if the party withdraws, doesn't participate, doesn't follow what it's supposed to under the contract, then the default award is going to be entered in favor of the party that's done everything that they're supposed to do. The validity of the award, all the things on the board here are important. Basically, the major takeaway from this is that it should be in writing and that it should be a formal, sophisticated, and completed document for the award. Basically, you want it to be as professional and as tight as you can get it. A practical note on this point is that even though failing to meet some of the requirements that we've listed up here is not going to completely wipe the award out altogether, you really don't want to give any party on the other side, especially if they were not the ones who won the award, you don't want to give them any leg to stand on or anything to do as far as challenging the award. You really want it to be a tight document. Also, time limits are involved. Generally, the parties, or once they submit a question or a contract for arbitration, they're going to set a time limit for which the arbitrators have to decide the issue, and if they cannot figure it out, then the parties are going to either take it to court or do something else with it. However, this is good because the parties retain more control over the arbitration. However, as a practical note, you shouldn't put too stringent of a time limit on this kind of a situation, because if you do so, you may not allow the arbitrators enough time to make a full decision, and you may be out where you didn't really want to be out. Also, one minor point, clarity. A lack of clarity could be grounds to invalidate the agreement, as I've said before. Remedies and costs. Obviously, the most common remedy that any company is going to want is going to be money damages. This is going to be basically to bring them back to being whole under the contract. Also, it's very prevalent to award an award of interest on top of the amount of time that the party, when they should have had the money up until the end of the arbitration agreement. However, as a very specific but practical point, certain Islamic nations and others have religious or other problems with an award of interest. And so to get around this, the arbitration panel calls these awards for these types of people a compensatory indemnity in lieu of interest. And so this is really granting them an award of interest without actually calling it interest and offending their religious sensibilities. Punitive damages rarely awarded in arbitration for a lot of reasons, but when the arbitrators really feel that punitive damages are necessary and it's available under the law, they will sometimes enforce a punitive damage. The res judicata effect of the award is very important to remember, that under arbitration, once an award has been confirmed by the court, it has the same res judicata effect as a court judgment. It's literally as if the issue had gone all the way through the court and had gotten rendered in a final judgment. Okay, next, the confidentiality of the award. This has been touched on a couple of times, but this is a very important point, especially if your client is a company that is a publicly traded company. We've seen in recent years what rumors on Wall Street can do, what big judgments in court proceedings can do, and arbitration is no different. If there's a major award or even a rumor of an award on Wall Street, you really don't want this getting out, so you really want it to be as confidential as possible. And that's another reason to do arbitration in the first place, to make sure that you can, even if you get killed under a contract that went against you, everyone's not going to know about it as they would in a litigation proceeding. Also, as a minor note, after the post-award proceedings, the arbitrators may make a correction on its own or in response to a request from either party made within 30 days of the receipt of the award, and that's just a minor procedural point. And now to wrap up, I'm going to hand it back over to Kaitlyn.
Thanks, Nathan. Now that you've got a favorable arbitration award, the next step for your clients will be to enforce this award in a jurisdiction where the opposing party maintains assets or conducts business. In most situations, this enforcement will be conducted under the New York Convention, which requires signatory states to recognize and respect arbitral awards from other nations as binding. This can be found in Article 3 of the Convention and otherwise referred to non-domestic arbitral awards. As a practical note, the New York Convention further establishes that a party wishing to enforce an arbitral award in another country will establish a prima facie case for validity by providing a certified copy of the arbitration agreement and the award to the enforcing country's court system. Now we're going to head back to our hypothetical. We're assuming that Thornbush Inc. has a valid agreement and a valid arbitration award, so the company can enforce the judgment against HBK in Germany under the New York Convention. Under the Convention, Thornbush Inc. is in a very secure position, as the existing presumptions in favor of validity ensure that a German court will enforce the arbitral award against HBK. In such a case, Thornbush or any other client with a valid arbitral award will be able to satisfy the Convention in order to ensure enforcement. This will include, and as this convention covers a vast majority of countries that you and your clients will be working with, this is very important. However, for the sake of argument, let's pretend that the arbitral award did not rule in favor of your client. If Thornbush Inc. is not successful in the arbitration, they will likely want you to challenge the arbitration or attempt to have the final arbitrator's award set aside. Generally, a party will attempt to prevent the enforcement of an arbitral award by challenging it in the judicial system. This action will most likely be directed at courts in the situs of the arbitration because they're presumed to have supervisory jurisdiction over the arbitration process. In addition, the New York Convention sets out several avenues for parties to invalidate or set aside arbitration awards. These are mostly related to the argument that the arbitration agreement or the arbitration process had some sort of deficiency. And these arguments include that a party could argue the matter at issue is not capable of being arbitrated or that the original arbitration agreement is not valid. Furthermore, the recognition of the arbitration can be set aside if courts determine that doing so would be against the public policy of the forum states. For example, in some countries, bankruptcy is not able to be arbitrated, so public policy argument would work there. However, these challenges are considered very risky and would be an uphill battle for you and your client. So you should only undertake this avenue in the most extreme circumstances. In the alternative, even if a court is not willing to set aside an arbitral award, a losing party could attempt to prevent its enforcement in the country's courts under a few limited arguments. These arguments are also generally based on severe issues with the arbitration process and are only successful in very limited situations. Heading back to our hypothetical, if Thornbush Inc. is unsuccessful in the arbitration process, they're probably in a poor situation because the arbitration agreement was drafted by an attorney skilled in the practice of transnational arbitration, you. So it is unlikely that a court will allow the agreement to be set aside or the award not to be enforced. Thornbush Inc. could attempt to argue under public policy that the contract is against the laws of the United Kingdom. However, this would likely be a failing position. Ultimately, challenging a valid arbitration award and final arbitral award are unlikely to be successful, and again, should only be considered in extreme situations. That being said, we're going to hear from our expert, Andrea Karska, one more time.
Under Federal Arbitration Act are much easier to raise in order to overturn. When you turn to the New York Convention, it's a totally different cup of tea. I have not seen it in my practice, but I read about, for example, several cases here in the US, but one of them was this athlete called Ovechkin, who's a hockey player in Russia, and there was a award against him in Russia, and he tried to enforce it in the United States, but it was refused enforcement based on the absence of the agreement. It was refused based on Article 2 and 4 of New York Conventions. U.S. courts have not recognized the arbitration award, and in order to recognize arbitration for an arbitration, you have to show that there was an arbitration agreement. And in this case, in this Ovechkin's case, they were not able to come up to give the proof that he really was part of the arbitration agreement about the dispute with the team in Russia. So I have seen it in other cases, not in my own practice. And there were some cases, I recall one of them, where there was non-enforcement based on public policy reasons. And that was in the case where, let me give you the name, if I find it, when there was given interest rate by French arbitrators, which was not just a compensatory, but it was 5% interest rate, which was like a penal to penalize the parties. And then there was a review on it in the United States, and there was a conclusion that this penal interest of 5% was against the public policy, and the enforcement was not granted in the United States. So that was under 5.2. That's where this was vacated. Of course, the parties try to use these grounds for non-enforcement, but it's a high level of hurdle to satisfy, whether it is here or in some other jurisdictions.
Thank you for coming. We really appreciated your time and attention, and we hope you learned something about transnational arbitration. If you're looking for more information, please visit our website for tips and practice pointers on transnational arbitration. At our website, you'll find several courses on the subtopics we've covered here, as well as a blog where you can provide any questions you might have, and we'll be happy to answer. Thank you again.